So we have some important and actually very interesting news in the current efforts to remove suppressors and short-barreled rifles from the NFA nationwide. A federal court has issued a new order scheduling some oral arguments that will happen revolving around this NFA case at the end of this month. And more importantly, the judge has now laid out the specific constitutional questions that he wants both sides to prepare to answer during those arguments. And when you read through these questions, it becomes very clear that the court is taking these NFA plaintiff arguments extremely serious, and this isn't a situation where the judge is simply scheduling a hearing and moving on. Instead, the court issued what is essentially a roadmap showing exactly where the battle lines will now happen in this NFA challenge. So let's talk about what is now happening. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button that just tells the algorithm that you appreciate this content, and so it shares it with more people. So we need to talk about what is happening right now in response to the $0 NFA tax change that passed through the One Big Beautiful bill. Now, if you've been following the channel for a while, you will know that under this new law, the NFA tax has been reduced from $200 to $0. Now, recently, organizations like FPC, SAF, NRA, the ASA joined together to file a similar lawsuit, a challenge against the NFA and its current restrictions on SBR, suppressors, and all of these items, and that was filed in the Eastern District of Missouri, which is under the 10th Circuit's jurisdiction. SAF argues that this regulatory regime no longer comports with Congress's constitutionally enumerated powers, and in response to the NFA no longer being valid under Congress's taxing powers, the plaintiffs asked for the court to declare that the NFA's requirements relating to the now untaxed firearms, including SBRs and suppressors. They wanted to be declared that that exceeds Congress's taxing powers both facially and as applied. They also asked for the ATF and all of its officers, agents, and everyone involved to be enjoined from enforcing the NFA against these now untaxed items. So this in essence would block the ATF from enforcing the NFA against suppressors, SBRs, and all of these untaxed items. Well, now the court in this case is taking action on this issue. The judge has now ordered oral arguments to take place this month on June 25th, and he outlined various questions that he wants directly addressed in supplemental briefs and also during those oral arguments. In this new order, the biggest issue identified by the judge is the same issue we've discussed on this channel since Congress, reduced the NFA tax to $0. The court specifically wants the parties to address whether the NFA's registration requirements for making and transferring suppressors and SBRs can still be justified under Congress's taxing powers now that those firearms are no longer subject to those traditional making and transfer taxes. So in other words, the judge is directly asking both parties whether these registration requirements still serve any legitimate tax collection purpose at all. Now that is huge because that is a critical issue in this case, and it's also developing in some other cases as well, because that is the core constitutional argument being advanced by the plaintiffs right now in these challenges. In this order, the judge also focuses heavily on the government's newest defense of the NFA. So as we've discussed recently, the DOJ is no longer relying primarily on the making and transfer taxes that historically justify the NFA. Instead, the DOJ is now arguing that the registration system remains constitutional because it helps enforce the special occupational tax paid by certain businesses involved with NFA items. The judge specifically ordered the parties to explain whether the NFA's registration requirements actually aid in collecting that special occupational tax, and whether that issue is a question of law, fact, or some combination of both. Now that is significant because it tells us the court recognizes the special occupational tax argument may be the government's last major avenue of preserving the current system as it stands. Now, the court also wants briefing on whether the NFA's registration requirements are actually necessary and proper for enforcing that special occupational tax. Now, that is important because even if the occupational tax itself remains valid if it moves forward, that doesn't automatically mean that the registration system still survives. The government still has to show that forcing registration, fingerprints, approvals, photographs, and all of the accompanying requirements are still sufficiently connected to the enforcement of that tax. And the judge appears to be questioning exactly how strong that connection still actually is. Now, what's also notable is the court is not limiting this hearing solely to the taxing power arguments. The judge is also requiring the parties to address major Second Amendment questions involving both short-barreled rifles and suppressors. For example, The court specifically asked whether SBRs should really be treated the same as short-barreled shotguns under the modern Second Amendment doctrines. The judge also asked whether suppressors qualify as protected components of an arm in the same way that magazines are often treated as protected components of firearms. So those are major constitutional two-way questions that could have implications well beyond just this one specific case. And if the court rules in our favor on some of these issues, it could impact other cases as well. Now, finally, the court wants the parties to address whether the NFA should be viewed as a registration system and whether registration systems are constitutionally different from licensing systems under Bruin and Heller. Now, that matters because one of the most common defenses of the NFA right now by the DOJ is that it functions more like a registration requirement than a prohibition. They tried to frame this as a shall issue licensing regime. The court now appears interested in determining whether that distinction actually matters under this modern Supreme Court precedent in Bruin and Heller. So stepping back, this order gives us an important glimpse into what the judge is actually thinking. The court is not brushing aside these plaintiffs' claims, and their challenges under the Second Amendment and also the whole taxing power arguments. Instead, the judge has identified the exact constitutional weaknesses being attacked by the plaintiffs and is demanding detailed answers from both sides. He wants to look at the taxing power issue, the occupational tax theory, the necessary and proper clause, the Second Amendment status of suppressors and also SBRs, and the constitutionality of the NFA's registration scheme and if it is actually a shall issue system like the DOJ claims. And all of this will be the focus of the arguments that have now been set for later this month on June 25th. So this case just became much more important, and we got a good glimpse into how the judges actually think about these issues and what he wants to address during those arguments. The court has revealed the constitutional questions that he thinks are most important, and a lot of these actually favor us, and he's not ignoring any of these pro-2A arguments or any of these issues being brought up by these 2A organizations. And based on the issues identified by the judge, it's clear that the court is preparing to seriously evaluate whether the federal government can continue enforcing these NFA restrictions when the taxes that historically justified them have largely now disappeared because of the $0 tax change. So that is what's now developing in this critical NFA challenge after the $0 tax change. This could have huge implications for the future of suppressors, SBRs, and all of these NFA items. And these organizations are trying to fight back against the DOJ's current positions, and it seems like the court is now taking this very serious. And so now we will see how these supplemental briefs, move forward. What is the DOJ going to argue? How are they going to answer the court's questions? And then we will also see during the oral argument, how does the judge feel about some of these issues? So as we get more information, as this unravels more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.